I'm okay.
Still going.
Are we live? We live yet?
Yes, let's go.
Okay. All right. Good morning, everyone, and welcome to this week's Community Cafe. We are live on Zoom.com as well as Facebook Live. We have with us today my co-host, Glenn Stockton, attorney with Stockton Stern Law Firm. Tongue-tied here today. Myself, Mark Roberts, owner of Affinity Asset Management. The third leg of our stool of our Community Cafe, Chris Toman's not able to be with us here today. Today's topic is we're going to talk about powers of attorney. Couple different things on powers of attorney, and we're going to use this as kind of like an interview format. We got a lot of questions as a financial advisor and as a person who's gone through the estate planning process. I plan to fire off at Glenn and ask some questions there. Before we get started, for those of you who are watching this on Facebook Live, do me a favor, click the share button and share us with your people in your lives. And maybe when we get done, if you don't mind, go out on Facebook and go to our Community Cafe Facebook page and click follow. That way, as we do things, we get updates, we can be able to send that to you through Facebook. I also find the best way, if you have questions on this topic, probably the best way to get a hold of us is just right here on Facebook. Just send us a Facebook message right here to our Community Cafe. Depending on what the question is, we'll make sure we reroute it to either myself or to attorney Glenn Stockton, get these questions answered for you. So probably the best way to do that here. So Glenn, thank you so much for joining us here yet on another Wednesday morning. Today we're going to talk about powers of attorney. I hope you're ready because I'm going to be firing lots of questions at you.
All right, I'm ready. Bring them on.
All right. First off, let's ask the typical question is how many different types of powers of attorneys are there?
In general, there's two basic powers of attorneys. Your power of attorney for financial decisions, managing finances and property, and a healthcare power of attorney. Appointing somebody to make healthcare decisions for you. So those would be the two primary categories of powers of attorneys.
Financial power of attorney and a healthcare power of attorney.
Correct.
Now, in my world, I would always call somebody a power of attorney. And I know a power of attorney is kind of more of a term of what it is, but isn't that person, if I pick my wife as my power of attorney, doesn't she have a different title? What is your industry call an actual power of attorney?
So the power of attorney is the power you're giving somebody. So that we call the document a power of attorney or a letter of attorney, but the person who you appoint to make decisions on your behalf that you're giving the power of attorney to is an agent. And the person who makes the power of attorney, like if I'm creating a power of attorney, I'm the principal, you're my agent, I'm appointing you to make decisions for me, giving you that power of attorney. But most people refer to that agent as their power of attorney. So for purposes of today's, cafe, I'll just refer to that individual as a power of attorney rather than calling them an agent. But
the reason why I ask that is because I've had people ask me about agent, and the first thing that comes to mind to them is an insurance agent. And I'm trying to tell them, no, it has nothing to do with something like that. So that's just the legal term of what we call that person. But if you want to just call that person a power of attorney, that's what we're going to call it.
Yep, that's what we'll do for today's cafe for sure.
All right, so let's start off with this. Glenn, what is a power of attorney?
So power of attorney is a legal document by which someone appoints another person to make decisions for them on personal matters. So with a healthcare power of attorney, they're appointing some other person or persons. You can appoint more than one, but you're appointing somebody else to make healthcare decisions for you when you're unable to. On the, a financial power of attorney, you're appointing somebody to make decisions regarding your finances, your property, your business affairs, those types of things. So it's just a document appointing someone else to act on your behalf when you're unable to do so.
But it's only when you're unable to do so.
Not necessarily.
So someone can't step in. So my power of attorney can't come in and override me as long as I'm mindful and fully capable. I make my own decisions. A power of attorney is only to be there when I'm physically or mentally unable to make those decisions, right?
Well, not necessarily. Often that is the case. That is what most people do, is they appoint someone to make decisions when they can't. Certainly with healthcare, doctors are going to look to you to make your own healthcare decisions for yourself, as long as you're capable of doing so. But if you're not able to, they'll look to that agent that you've appointed under a power of attorney. When it comes to finances, on the financial side, I often tell people, I mean, the key is you got to appoint somebody you trust, right? Give them a level of trust. But here's the downside. Most powers of attorneys that people bring to me, it says effective upon my incapacity. And then how do we determine incapacity? Well, the standard is by 2 licensed physicians in writing or a court of competent jurisdiction. That's the most common way people do it. What's the problem with that? In order for your agent to act on your behalf when you're incapacitated, you've had some sort of crisis, you've had a stroke, something, an accident, something, they may be in, we're in crisis mode. We need to do asset protection planning. We got to get access to the assets, but they can't. They're waiting on doctors to examine you and write their letters, and that can take weeks sometimes to get those letters. In the meantime, nobody can act on your behalf. So what I tell people is there's no right or wrong answer, but consider this. If the person that you're going to give, you ought to trust them, because if they're going to make decisions for you when you're incapacitated and don't know what's going on, could we trust them to give them that power, make it effective immediately, and just tell them, hey, you don't even necessarily have to tell them it's effective immediately. When they get say, I've got a power of attorney, you're my power of attorney or my agent, and it's, here's where you'll find it when you need it. But then they can act immediately. If we have a crisis, they can immediately act. We're not waiting on doctors. If people are not comfortable with that, then I say, well, what if we created a private disability panel? Instead of saying it takes 2 doctors to certify in writing that you're incapacitated, what if you set up your private disability panel? My spouse and my 3 children, and the majority of them, or unanimously, if they agree, they can say, hey, Dad, we're taking the checkbook away, right? I trust them. And so it's not effective until they all agree to that. It might be another way. But with all these documents, and when we do estate planning, this is an estate planning document, we always have to be thinking, what's the end game? How does this thing actually come into play? When are we going to need it? And what does that look like? And I think people do not give this stuff enough, thought as to how this is going to play out. So I tell people, no right or wrong answer. Consider making it effective immediately. You have to understand, a power of attorney, we said, what is that? It's a document to appoint somebody, but this is your disability plan. If you become disabled, incapacitated, unable to make decisions for you, this is what gives somebody the ability to make decisions for yourself. And if we don't have this, there's still an answer. We got to go to court. We've got to file for conservatorships and guardianships. So the powers of attorney is powerful incapacity planning document. And we just have to think, how does this play out? No right or wrong answers.
Well, one of the things that makes me think is in 24 years of doing this, I've had powers of attorney contact me, asking me questions about somebody else's account. And then they try to tell me, well, I'm the power of attorney. Okay. And they will literally provide me with a copy of the power of attorney document, but it's not necessarily enacted. It's kind of like a kid wanting to get information on their parents' assets, probably just for their own nosy reasons, where I was having to shoot them down because I know that parent's perfectly fine, perfectly healthy. And they have the power of attorney, but they don't have the power of attorney to get information until it's necessary, I guess is the easiest way to say it. So needless to say, I think there are some kids in the past that got in trouble with their parents for wanting to be nosy, asking questions behind mom and dad's back. So that's kind of why I was asking that question. I've had that come up before. So one of the other things I have come up, Glenn, is some people think I have to have a certain size of assets before I need to have something like an estate plan. And to you and me, estate plan means something different than to them. Everybody thinks estate plan means I have to be wealthy. But it's not true. Anybody needs some kind of an estate plan, some kind of basic documents. And I believe no matter how size your assets are, big or small, everybody needs some kind of power of attorneys. So I was going to ask you, who's the typical type of person that needs a power of attorney?
Yeah, I agree with you. we all need power of attorneys, right? And certainly the older we get, the more likely from a statistical standpoint, the more likely we're going to get to that point where we're unable to make decisions for ourselves. But it can happen to anybody. So once somebody turns 18 years of age, parents no longer have the ability to make decisions for them. So when kids go off to college, as a parent, I want to make sure that, my kids have a power of attorney because, for healthcare, I can't make healthcare decisions for them just because I'm their parent. They're now an adult. I no longer have that parental authority. So unless they've appointed me or someone else as an agent or power of attorney, if they're in an accident, they have some serious health issue, and are unable to communicate their wishes, I've got to go to a court and get appointed to do so. So at 18 years of age, we ought to have one. But certainly the older we get, the chances of us getting to that point of not being able to make decisions increase. But for every client, when I sit down to meet with them about an estate plan, the estate plan encompasses, many documents, but your healthcare and financial power of attorneys are two of those documents. Your will, your HIP authorizations, living wills, all those things can be part of it too, your trust. But powers of attorneys are a vital piece of this. As I said before, it is your disability plan. We all need one because if tragedy strikes, we'll be ready and we won't need the court's involvement at that time.
Oh, that's a great answer. Okay, so I got another question, and I know the beginning part of the answer, but I'm going to let you kind of finish the ending part. It's, who should I appoint as my power of attorney? And I think typically married couples will use their spouse as their first power of attorney. A lot of times people will use their kids as power of attorneys, somebody that they love and, more importantly, trust. But beyond the obvious of a spouse and children, who should people use as their power of attorney?
So, the most typical is spouse and children, but for those who either don't have a relationship, aren't married, don't have kids, or, don't have a relationship with those people that they have the necessary trust, there are professional fiduciaries out there that can serve. Chris Tillman, who's part of our cafe with First Option Bank, we've appointed First Option Bank and Trust as agents under power of attorneys for several of our clients. They're in that way. But I go back to, who should you appoint? Somebody you trust. The other thing I would tell you, Mark, is most people think I have to appoint one person. And on the financial side, I generally think it's best to have one person who is appointed to make those decisions. Have a backup in case that person can't act, but one person at a time, in my experience, works best. But on the healthcare power of attorney, I often tell people we at least ought to consider, what if we appointed, your spouse and all of your kids, or your spouse primary, and then if your spouse can't act, then your kids, and appoint them all. So we have multiple boots on the ground. If you have any kind of extended hospital stay, having multiple people that can divide up that duty, like, hey, I got something going on at work today. Can you get mom take her to the doctors today? They can divide that responsibility. Again, no right or wrong answers, but we don't have to, choose one child over the other. If the kids get along relatively well, we can appoint multiple people. Now we have to think through, what if there's a disagreement, but we can handle all that in this document. Again, this is your disability plan. Who is it you want acting on your behalf? And if you don't have those family members or, people close to you, then we would look to the professional fiduciaries to serve that in that role.
And I think you were just kind of already answering what I think my next question is can you appoint more than one person to be your power of attorney? And I think the easy answer is yes. And you can do multiple different ways, right?
Yeah, absolutely. Absolutely. So one person, and then if that person's not able, then it could go to, you could appoint two or three and, four, however many you want to say, but generally, if you're going to appoint more than one, as a general rule, especially on the healthcare, you want to give them the power to act independently. You don't want them to have to all show up to be able to make a decision. That can slow it down. If we're going to appoint one on the financial, sometimes people want safeguards, and they'll say, I'm going to appoint, both my kids or all three, but they have to agree. But again, think it through, because that requires that they all your agents sign off on every check, and they all have to jointly make decisions. That can become very cumbersome. So just what is the plan for you? How do you want that to work out?
And I think you've answered this one actually earlier, with kind of answering another question. You kind of added this, but I'm going to kind of bring it back because I want people to hear the simple answer to this question is, when do I need my power of attorney?
When you are unable to make decisions for yourself, at the point you're incapacitated, whether it's temporary incapacity, been in an accident or something, unable to make decisions, or it's a long-term permanent, disability. You've developed dementia, Alzheimer's, and no longer able to make decisions for yourself.
I think a good way to, I've found a way to kind of describe a power of attorney is, a power of attorney is going to be needed when you don't know it's needed. Because if you are of sound mind and everything else, then you don't need your power of attorney. You're going to make your own decisions. But it's always going to be needed when you are not aware that it's needed. It's your loved ones, it's your spouse, it's your family that knows that there's some problems. Whether it's, like you say, you're in a coma, you're in the hospital, or you have dementia and all kinds of other things. You'll never know that power of attorney is being enacted. And you need to make those decisions and pick those people while you are of great sound in mind, because any one of us can have a stroke. We just got a terrible phone call the other day from somebody who's only 7 years old, just having a heart attack. And the wife called us, and he's not looking good. He's still alive, but right now he's in a bit of a vegetative state. And his wife has the power of attorney. Thank God they had those power of attorney documents as being enacted where she can help make decisions for him. But up until then, like a week before this, perfectly healthy.
Right.
And so the power of attorney is going to be there when you don't know it's going to be there. Is that a good way to say it?
I mean, certainly that was going to come in, but oftentimes it'll come into play. People will decide, as we get older, sometimes we start realizing that we're not able to analyze information the same way we did before. So I have lots of clients who have said, hey, I have my kids helping me now. They're helping me with bill paying. They're helping me make decisions when they get a letter, about something they're not really sure whether they should make that decision. And so they like to have, one of their kids or somebody they trust that kind of is able to come along and help them with that process. So again, we definitely need it when we're unable, we don't know what's going on, because there's no way we can act. But sometimes we still have the ability to act, but we want our spouse or one of our kids to act on our behalf. Oftentimes for spouses, they want, I want my spouse to be able to sign checks and do things. So, I'm off at work or something. So with a spouse, again, what if we made that thing effective immediately? Give your spouse the power to, call up and talk with Social Security Administration, to apply for Social Security, cash checks, do those things. You choose when it's effective. But certainly when you don't know what's going on, you need a power of attorney.
So, okay, so my next question, I actually think we've answered this, but I kind of want to circle back onto a different way. The question is, when does a power of attorney take effect? And of course, that's what we've been talking about. So kind of to hit that a different way is, power of attorney is going to take effect when obviously we don't know that we need it and somebody else is having to come in and make those medical or financial decisions. So what I have found is, as people age, they'll want to put one of their children or maybe a couple of their children as co-owners or joint owners of some of their property, like bank accounts, checking, savings, their house, the deed of their house, things like this, where I try to ask them, now tell me why you did that. And they'll say, well, if something happens to me, then they have instant access to that account, or they actually take ownership of the house if I die and things like this. And so when you peel that back, the answer is always a simple answer and a very common sense answer they give me. But at the end of the day, that's not the right way to go. You don't want to put kids and things as co-owners of accounts or joint owners. What you want to do is leave them off, have it just you or just you and your spouse. But what you want is those power of attorneys in place. So that way, in the event you need your kids to access the accounts, they can access the accounts through the power of attorney. You need to make decisions through the power of attorney without the liabilities and the risk. Because if we put our kids on as joint owners of our bank accounts or the title to our house, the deed to our house, problem is one of those kids get into a small car accident, they get sued by somebody, their creditors, their debitors, whatever, can come after everything that their name is attached. That means they come after mom and dad's stuff too. Would you agree with that?
I absolutely agree. There's typically better ways. I mean, there can be circumstances where it can make sense to put a kid on an account, but we need to think it through. You know, you put one icon, so you brought up the house, you put the kids on the home while you're alive as owners. You didn't do them any favors by doing that. Yeah, we're going to avoid probate. Yeah, they've got the ability to, you know, make sure, but I mean, you still have, without a power of attorney, they can't sell it. You know, you have to be able to sign. They're going to have to sign, but if you're on the title with them, you're still going to have to sign. But we'll avoid probate. But what's going to happen now is we didn't do them any favor because they inherited your tax basis. They didn't get a step up in basis. So another topic, but I tell people putting the kids' names on accounts is probably not a good idea. Plus, unless you put all the kids on there, when you die, if they are a joint tenant on your bank account, that child is now the sole owner of that. And they're not obligated to share it with their siblings or the other beneficiaries because it's their account now. The beneficiary stuff never came into play. And if they do, out of just doing the right thing, decide it, well, now they're gifting and they may require gift tax returns and stuff to be filed. So use powers of attorneys to give people the authority. You can, on bank accounts, make them authorized signers, which is in essence, the same thing, but don't put them on accounts.
Yeah, I like how you said that because people will put a child on an account or, you know, a property with the intent that when they die, that child gets that property. And the goal is that child's responsibility is then to divide it up amongst the other siblings, you know, the other kids. And, you know, that kid may be very trustworthy and may actually very well do that. Of course, not legally required to, but they will say, and then that's what parents tell me, oh, my child will do this. Problem is now you have, like what you just said, gift tax problems. And there's a gifting tax out there. So now myself, if I was to inherit property from my parents, where I'm the owner of it and my parents died, now I'm the sole owner of it. And then I'm supposed to sell it and give half that to my sister. Now I have tax consequences to myself to give it to my sister, even though that was my parents' intent the whole time, is to go 50-50 to me and my sister. But the route they gave it to me is they put me on as the owner. They died. I became the sole owner. And then I have to take half that and give that to my sister. It doesn't matter what the property is. Now I have gift tax problems with my sister of giving this just to accomplish what my parents want. There was other ways to do it so much more efficiently.
Yeah.
So Glenn, let's shift gears. We've been talking about these powers of attorney, and I want to kind of go down a slightly different path here. I want to talk about healthcare directives, like a medical directive. Can you first explain what is a medical directive and what is the difference between a medical directive and a healthcare power of attorney?
So a healthcare power of attorney is one of our medical directives or advanced directives, right? Medical directive is just appointing people or making decisions in advance, right? Giving direction. So it's a directive, giving somebody direction about medical decisions. So the healthcare power of attorney is appointing who's going to make those decisions on your behalf and what types of decisions they can make. Other healthcare directives would be an important one would be a living will, right? Or dying declaration. This is the pull the plug document that's going to make decisions about what type of care you want when the doctors have determined that, you know, you're dying and there's nothing they can do to stop it, or you're in a persistent vegetative state, you're in a coma, never coming out of it. Now that is a document we can't get around the 2-doctor requirement, right? Law requires that in order for that document to come into play, 2 doctors must certify in writing either you're terminal and there's nothing to do to stop it, or you're in that persistent vegetative state. But you've made decisions in advance, and it's one that I get passionate about. We've talked about this, I think, in a prior cafe. I say, you know, if you don't make that decision in advance, then you're leaving that to your loved ones, and they will live with that decision for the rest of life. And kids, even where they get along very well, this is one of those areas which get very emotional. And one kid thinks you're making the decision too quickly to, you know, remove mom from a feeding tube, or, you know, take dad off the ventilator, whatever the case is, or they think you left them on too long, you let mom or dad suffer. And so I tell people, if you're going to put it on your kids, be very intentional about that. But for most of us, we should make that decision for ourselves. Hope it never comes into play, that we, many, many years in the future, we pass silently in the night, peacefully in the night. And we don't, you know, for most of us, we don't have those decisions. But a healthcare power of attorney is one of our medical advanced directives. Your living will is another, HIPAA authorizations, you're authorizing people who can access medical records. Those would all be types of medical directives.
Three types of medical
Three
directives.
primary, for most people, those would be three. I mean, there's others, do not
Living-
resuscitate or DNRs and all that, but
Okay,
three
that was
primary
that-
ones for estate planning are your living will, healthcare, power of attorney, HIPAA authorization. DNR, I tell people that should be done in consultation with your doctor. That's a different document. Often
Okay.
confused.
Okay. Let's wrap this up with two more questions here. When do I need to update my advanced directives?
So on your financial power of attorney, the recommendation is you update them, every 3 to 4 years, certainly within 5 years. There's nothing in the law that says they expire, but if someone walks in with a power of attorney to the bank or to a financial institution and wants to close out your account, you've got $100,000 this account, and they come in and say, hey, I want to close it out and take the money, and that thing's 20 years old, good luck, right? They're not going to honor it in most cases because they're just too much time's passed. So recommendations, you update them every few years. I know with our clients, we update them annually when we meet with them for the annual review meeting. We don't have to charge our clients for it. We just change the date, print, sign a new one, but at least every few years. Medical power of attorneys, we really don't have that problem. They need to be updated if circumstances change. If you've got somebody else you want to appoint, or you've made a different decision about things. But we don't have the issue with them becoming stale over time. The doctors are perfectly fine. Never had an issue where they, deny one because it's been done many years ago. Financial, we see that frequently. So keep that one up to date.
All right. And last, let's finish this. Who are the people in our lives that should have copies of these directives? So we keep a copy for ourselves, but who else should have a copy of this?
So on your medical directives, having your doctor and your hospital that's in your network, having them on file there can be a good idea. Making sure your kids, have a copy of that, or at least know where to find it. On the financial one, because you're updating that frequently, I tell people, I think a better rule, rather than giving copies to your kids and agents, is just let them know where to find it when the time comes. Right. One, that would kind of help solve that problem. They get, nosy. They're not able to just send it over to the financial advisor and say, I want to know how much money mom and dad have. They don't have immediate access to it, but they would know where it's at. It's stored at mom and dad's home in the safe, or it's in the lockbox. That way, every time when you update it, we can shred it. We don't have to go say, hey guys, I need all your old copies, throw those in the shredder. Here's the new one. So just as long as they have nowhere to access it, it's generally a better practice.
Well, Glenn, that was awesome. We literally took a full 25 to 30 minutes on powers of attorney and healthcare directives. That's very detail oriented. You made it very simple. You make it very easy for me and my entire office at Affinity Asset Management to refer you and your entire team over there, your lawyers and your back office people, to refer you guys to our clients. You guys do it right. You guys do it thorough. You guys keep it simple. And more importantly, you explain things in a way that clients can understand without talking a bunch of legal jargon over their heads. And I thought that's exactly what you just did here today, is you really took a complex topic and simplified it down. So nice job, Glenn. Thank you so much.
Yep. And just, guys, you just take, this is your disability plan. If you haven't done your powers of attorneys, or you haven't updated where it's like, get this done, you need to have this in place. You'll avoid being a burden. It's going to make things a lot easier. So Mark, thank you.
Well, everybody who's watched this video here live on zoom.com as well as Facebook Live, thank you for watching. For those of you who are going to watch this later on a recording of this, again, thank you for watching. But do me a favor, share this video with your loved ones by clicking share. Go out to our Facebook page on Community Cafe and follow us as well, so you can get future updates. We do this every Wednesday at 8 a.m. live, but as most people know, that they can watch that later as it pops up in their news feed on Facebook and such. So thank you, everybody, for joining us. Thank you, Glenn, for co-hosting with me here today. You are awesome. Everybody, be healthy, be safe.
Thanks, Mark. Appreciate it. Take care, everybody.